We'll now talk a little bit about how a bill becomes a law, using as a case study House Bill 102 from the 2015 legislative session. A bill is a proposal for the enactment of a new law, the amendment or repeal of an existing law, or the appropriation of public money. Bills can originate in either the House or the Senate, with the exception of revenue-raising bills, which must begin in the House. So for our example, we will follow the progress of House Bill 102 from the 2015 Idaho legislature from start to finish to see how the legislative process works. And it will also give us the opportunity to see how some of the technology that the legislature has put in place to allow folks to monitor the legislative process from anywhere in Idaho works, so that you can see that you don't have to be in Boise to keep track of what's going on in the legislative process. And so that's part of the reason for why we're going through this exercise, is to show you how easy it is to monitor the legislative process from anywhere in Idaho. House Bill 102 is sponsored by Representative Lynn Luker of Boise and Senator Todd Lakey of Nampa. And the bill reclassifies juvenile curfew violations under city and county ordinances from misdemeanors to infractions, provides for a $150 fine, and eliminates the potential for detention. And so the broader context of this legislation is really the issue of public defense reform and the effort that the legislature, as well as cities and counties, have made to try to work on this issue and to try and minimize the impact on public defense throughout the state. So House Bill 102 is one of several bills from the 2015 legislative session that reclassify low-level criminal misdemeanors to civil infractions. Idaho has a public defense reform interim committee that's been meeting for the last few years, studying how to strengthen public defense for indigent defendants and reduce caseloads on public defenders. So really, the low-hanging fruit in this process, one of the easiest ways to help the system, as well as reduce the burden on judges and prosecutors, is to transition low-level criminal misdemeanors to civil infractions. And because civil infractions don't involve potential jail time, there's no requirement for a public defender to be appointed in infraction cases. And AIC has been very supportive of this effort, and we've worked very hard to educate city officials about the importance of reclassifying low-level criminal misdemeanors to infractions. For some years, cities didn't have the ability to impose infraction penalties, and so city ordinances, just as a default, had misdemeanor penalties for things like barking dog and other sorts of low-level nuisance things. But now cities have the ability to levy infraction penalties and to include infraction penalties in their ordinances. And so this is definitely something that we're trying to raise awareness about and increase understanding among city officials about the importance of transitioning any of these legacy low-level criminal misdemeanors to infractions, to do what we can to help reduce the caseload on public defenders. This slide shows the anatomy of House Bill 102, looking at the bill itself to show you the basic parts of every bill. At the top, you'll see the number and then the committee that introduced the bill. So you see by Judiciary Rules and Administration Committee, which is the committee that actually introduced the legislation. So the section that starts "an act" is the title of the bill, which is in all caps, and is basically a summary of the bill. And Article 3, Section 16 of the Idaho Constitution requires all subjects that are covered in a bill to be reflected in the bill's title. Below the title is what's called the enacting clause, which is required by Article 3, Section 1 of the Idaho Constitution. And the enacting clause is, be it enacted by the legislature of the state of Idaho. So everything that follows that statement then has the force of law. The body of the bill then is below the enacting clause, and you will see In this piece of legislation, the code section that's being amended is Idaho Code 20-549. You will see that it proposes to strike some of the words that are currently in the law, which is reflected with the strike-through text. And then it also proposes to add new words to the code section, which are represented by the words that are in underscore. So the strike-through represents words that are taken out, and the underscore represents words that are added. Very similar to the way your municipal ordinances work when you're amending a city code section. This is the statement of purpose and fiscal note for House Bill 102. Every bill has to be accompanied by a statement of purpose and fiscal note. The statement of purpose is just a short summary of what the bill would accomplish in layman's terms. And the fiscal note states the fiscal impact that the bill would have, not just on the state government, but also on local governments. Legislative rules require that the fiscal note has to disclose any financial impact to local governments. And so the fiscal note is tremendously important as it gives you the financial impact that any proposal would have on the state and local governments. At the bottom of the SOP, you'll see the contacts who are the legislative sponsors. So the first step in the legislative process is introduction of the bill. And bills can be introduced by legislators themselves as personal bills, but in Idaho there's a very strong bias in favor of bills being introduced by standing committee. Bills that are introduced as personal bills generally don't go very far. Legislative rules require introduction by committee after the 20th legislative day in the House and the 12th legislative day in the Senate. After the 36th legislative day, only privileged committees may introduce legislation, and this is an effort in the legislative rules to kind of neck down or restrict the number of bills that are being introduced after this midway point in the session, the 36th legislative day. So as you approach that point, you'll see that the volume of legislation that's being printed really hits its peak. And then after that point, it drops way down as only privileged committees can introduce proposals after that point. New bills can still be introduced after the printing deadline, but it is more difficult. So in the House, privileged committees include State Affairs, Appropriations, Education, Revenue and Taxation, and Ways and Means. Privileged committees in the Senate include State Affairs, Finance, and Judiciary and Rules. Committee introduction occurs at print hearings, where the legislative sponsor provides an overview of the proposal and answers questions from members of the committee. At this stage, the proposal has not yet been assigned a bill number, and it's referred to by the RS number that's assigned by the Legislative Services staff to all legislation when it's drafted. An important point is that legislation in the RS stage is the actual property of the legislative sponsor, and it can only be released with the sponsor's consent. Once the bill is printed by the committee, then it becomes public and it can be reviewed on the legislature's website. Typically, print hearings are brief affairs where the committee makes a very cursory examination of the proposal and then votes to print it. However, if the committee uncovers real problems with the proposal, it may vote to hold or kill the RS. So our proposal, House Bill 102, which is shown here as RS 23286, was scheduled for a print hearing in the House Judiciary Rules and Administration Committee on February 9th, 2015. So this is an example of the committee's actual agenda for that day. It's second on the agenda, listed as curfews, penalties, / juveniles. We will now watch the print hearing for RS 23286. The sponsor, Representative Lynn Luker of Boise, will explain the proposal to the House Judiciary Rules and Administration Committee.
RS 23286 changes curfew violation to an infraction punishable by $150 infraction fine. And you can see the fiscal impact, and it's kind of a lesson on what's going on here, because when a misdemeanor fine is imposed, it goes down one revenue stream, and when an infraction fine is imposed, it goes down a different revenue stream. And so there are some adjustments going on here between these two streams of revenue, so it will impact different funds differently. Bottom line is, the hope is that this will save the public defender's cost, but at the same time it will shift some funds between different accounts. And this one is fairly small impact. It's $1,162 decrease in revenues spread between the various funds that you see there. So that's just for your information, the same type of fiscal impact review that you'll see in these other bills. So with that, I'd stand for any questions on this
RS
286.
Representative Luker, in these, what we are doing is really taking them out of the criminal and making them civil liabilities, right? Civil penalties rather than criminal.
Correct.
Okay. Any questions? Yes. Representative Trujillo, did you have a question?
Thank you, Mr. Chairman. Not a question, but for a motion.
Go ahead.
I move that we introduce RS 23286.
Okay, discussion on that motion? Hearing none, all those in favor signify by. Aye. Any opposed? Okay, thank you.
If the committee votes to print the RS, as it did in our example, then the next step is first reading. And the proposal is presented to the Chief Clerk of the House or Secretary of the Senate, assigned a bill number, and placed on first reading. At first reading, the title of the bill is read across the desk by the Chief Clerk of the House or Secretary of the Senate on the floor during the appropriate order of business, the 8th order in the House or the 11th order in the Senate. After the title is read across the desk, the presiding officer announces the referral of the bill to the Judiciary and Rules Committee for printing. The following day, then, the bill is reported as printed, and it's assigned to the appropriate standing committee by the presiding officer. So we will now watch as House Bill 102 is read across the desk in the House by Chief Clerk Bonnie Alexander. The next day, Speaker of the House Scott Bedke referred the bill to the House Judiciary, Rules, and Administration Committee.
House Bill number 102 by Judiciary, Rules, and Administration Committee, an act relating to curfews, amending Section 549 Idaho Code to revise the penalty for juvenile curfew violation. House
After the bill is read across the desk, then the committee chair decides whether the bill will be scheduled for a public hearing and when that hearing will be. At the hearing, the sponsor provides an in-depth summary of the proposal, and then the committee hears from anyone else who wishes to testify on the legislation, including members of the public. After the hearing, the committee may vote to hold the bill in committee, which kills the bill. It can be sent to the floor with a do pass recommendation, or the bill can be sent to general orders for amendment. House Bill 102 was scheduled for a hearing in the House Judiciary, Rules, and Administration Committee on February 19, 2015. And this is the actual committee agenda, showing it second up, and Representative Luker as the presenter. We will now watch the House Judiciary, Rules, and Administration Committee hearing on House Bill 102. The bill's sponsor, Representative Lynn Luker of Boise, provides a summary of the proposal, and then the committee members ask questions about the bill.
We have House Bill 102.
Thank you, Mr. Chairman, members of the committee. House Bill 102, again, is a reclassification of a misdemeanor to an infraction. This deals with curfew violations and simply changing it to an infraction with a $150 fine. So With that, I'd stand for any questions.
Questions? Representative McDonald.
I'd like to make a motion, Mr. Chairman.
Motion's in order.
I move that this be sent to the floor with a due pass recommendation.
Okay, you heard that motion. Representative Gannon.
Oh, thank you, Mr. Chairman, and Representative Luker. I am going to vote for this, but I did have a question on these. Would this include Boise City also, where they would have to conform to this too? And
Mr. Chairman, Representative Gannon, they could have their own curfew ordinance as long as they go through the proper process, and I believe they may already have that on the books. I don't know, but this is simply a state law that doesn't impair the cities from doing what they want to do.
Mr. Chairman and Representative Luker, is there a way that we can include the cities in a bill like this so that we don't have city misdemeanors? I've seen the Boise City Code, and there's many, many misdemeanors that they have in there. And I'm just wondering whether we can expand any of these laws that we're going through now.
Thank you, Mr. Chairman. Representative Gannon, that's a great question, and as part of the Public Defense Interim Committee, that has been an issue that's been out there for the Association of Cities and Counties, and they are all actually actively reviewing their own codes to make some of these changes. Whether they'll do it specifically with curfew or not, I don't know, but that's an active effort that's going on in the cities and the counties to review these.
Okay, Representative Nate.
Mr. Chairman, Representative Luker, I know with a misdemeanor, if you're charged, you do have the right to a jury trial. Do you know if any, and an infraction would not give you that right, do you know if any of these, anyone charged with these misdemeanors have pursued a jury trial?
Mr. Chairman, Representative, I can't tell you for sure how many. I assume that some have, but the exact numbers, I don't know. A lot of these I would expect are plea bargained out, but that still involves a public defender. Even if you actually don't end up in the trial, you have to have from the first arraignment a public defender assigned. So,
Mr. Chairman, thank you. Thank you.
Okay, Representative Nye.
Motion,
I believe we have a motion before us, do we not?
no,
We have a
Call it-
motion on the table now.
just call it question.
Yeah.
So,
Okay. So the motion is to send this House bill to the floor with a due pass. Any discussion? We have a motion before us. All those in favor signify by aye. Any opposed? Okay, thank you.
If the committee votes to send the bill to the floor, as they did in our example, then it is placed on the second reading calendar, and the title is read across the desk at the 10th order in the House or the 12th order in the Senate. The following legislative day, the bill is automatically placed on the third reading calendar unless other action has been taken. Third reading is the point at which the bill comes up for debate and vote on the House or Senate floor. Once the House or Senate reaches the appropriate order of business, the 11th order in the House or the 13th order in the Senate, then bills are considered in their order on the third reading calendar. And this happens unless unanimous consent is granted to reorder the calendar or consider another bill out of order, which happens frequently later in the session. House and Senate rules require that the entire bill be read across the desk by the Chief Clerk of the House or Secretary of the Senate during third reading. However, the bill's sponsor will typically rise and request unanimous consent to dispense with further reading of the bill. If any legislator objects to this request, then the bill must be read in its entirety. Floor debate begins with an introduction and summary by the bill's sponsors. Members are allowed to ask questions of the sponsors and debate for or against the bill. After debate is finished, the sponsors make concluding remarks and announce that debate is closed. At this point, the presiding officer announces the question. The question is, shall House Bill 102 pass? Members of the House of Representatives vote electronically, and their votes are instantaneously tallied and displayed on large screens on each side of the chamber. We will now watch the House floor debate and vote on House Bill 102 with Speaker of the House Scott Bedke in the presiding officer's chair.
The House will now have under consideration House Bill number 102. The gentleman from District 15.
Thank you, Mr. Speaker. I would request unanimous consent to dispense with the reading of House Bill 102.
You've all heard the request. Is there an objection? Hearing none, the gentleman has the floor to open the debate.
Thank you, Mr. Speaker. This bill, House Bill 102, is the first of the reclassification bills, and I'll explain a little bit more about the purpose behind that. As you may know, we have a issue with our public defense system meeting the workload that it's faced with, and providing the type of defense that is required. And as part of this, the interim committee has recommended a number of bills that would transfer penalties from a misdemeanor classification to an infraction classification. And the reason for that is based upon United States Supreme Court decisions. Anytime a charge carries a potential jail time, whether that's just a day in the county jail or on up, that brings in the need for a public defender for those that qualify. And so there are some low-level misdemeanors that can and probably should be moved to infraction status, which does not carry jail time. And this one deals with curfew violations of juveniles, and it removes the misdemeanor penalty and imposes an infraction penalty of $150. Again, this was a change that was recommended both by the Criminal Justice Commission and the Public Defense Interim Committee. And with that, I would ask for your green light.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill number 102 pass? The clerk will unlock the machine. The members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the vote. The roll call shows 65 ayes, 0 nay, with 5 absent and excused. House Bill number 102 has passed the House, will be transmitted to the Senate.
So since House Bill 102 passed the House, it now heads to the Senate. The bill was read across the desk at first reading and then referred to the Senate Judiciary and Rules Committee. The Senate Judiciary and Rules Committee approved the bill, and so it then went to the Senate floor for debate and voting. We'll now watch the Senate floor debate and vote on House Bill 102. In the Senate, voting typically occurs by roll call. The Secretary calls each senator's name in alphabetical order and records their vote on a tally sheet, just the way that the city clerk does a roll call vote at a city council meeting by calling each council member's name and recording their vote individually. Senators can request 1 minute to explain their vote if they have not debated on the bill. Near the end of the session, when the number of bills is at its peak, it is common for a senator to request unanimous consent to apply a vote from a previously considered unanimously passed bill to an uncontroversial bill that is currently being considered as a way to speed up the process. Roll call voting does take a lot of time, which is one of the downsides. If any senator objects, then a recorded roll call vote must occur. So we'll watch this example play out as the Senate considers House Bill 102.
Consideration of House Bill 102. Secretary will read the bill.
In the House of Representatives, House Bill number 102 by Judiciary, Rules and Administration Committee, an act relating to curfews to revise the penalty for a juvenile curfew violation. Be it enacted by the legislature of the state of...
President.
Senator Leahy.
I ask that further reading of House Bill 102 be dispensed with. The Journal show it's been read the third time at length, section by section, and properly placed before the Senate for final consideration.
Hearing no objection, Senator Leahy is recognized to open debate.
Okay. Mr. President, Senators, pursuant to a request to be a little more brief, this bill simply makes the curfew statute, which currently exists, and but the interest of taking a little more time and being a little more current in an example, curfew laws are established by cities or counties, and typically it's 11, 12, maybe a little bit later on the weekend. In my youth, my friends and I may have gone to the local grocery store and purchased the bulk package of Charmin 2-ply and gone over to a friend's house in the early morning hours and applied that to the real property of a friend of ours. The statute of limitations is long run on that. That describes various potential misdemeanors, but the first one is if you're out on the public streets after the hours established by the city or the county. Currently, that's a misdemeanor, and that means that that juvenile is subject to up to a $300 fine, detention, and probation. What this does is make it an infraction. In addition to that, they're also able to have the public defender if they have to go to court on a curfew. This makes it an infraction, simply a fine of $150. Again, it's an effort to reduce the expense both with the public defender and on our court system. And with that, debate is open, Mr. President.
Further debate? Hearing no further debate, Senator Leahy is recognized to close debate.
Thank you, Mr. President. Debate's closed.
Debate being closed. Question is to House Bill 102 pass the Senate. Senator Winder.
Mr. President, I ask unanimous consent the roll call vote used for the passage of House Bill 153 be now used for the passage of House Bill 102.
Hearing no objection, roll call shows 35 ayes, no nays, no absence. Excused, majority having voted in the affirmative. House Bill 102 is passed the Senate. The correction title. Hearing none, title is approved. House Bill 102 will be returned to the House. Senate.
When the governor receives a bill that's been passed by both the House and Senate, the governor has three options. The first is to approve the bill by signing it within 5 days after its receipt, excluding Sundays, or within 10 days after the legislature has adjourned. The second option is to allow the bill to become law without his approval by not signing it within the applicable period. Or the final option is to veto the bill within the applicable period and return it to the House of Origin, giving the reasons for disapproval. If the governor vetoes a bill, it can still become law if the House and Senate vote to override the veto by a 2/3 majority in each body. So House Bill 102 was delivered to the governor's office on March 24th, 2015. Governor Otter signed the bill on March 30th, 2015, which is 5 days after its receipt, not counting Sunday. And the bill went into law and took effect on July 1st, 2015, which is the standard enacting date for most legislation that doesn't have what's called an emergency clause, which causes it to take effect as soon as the governor signs it. Most bills have the default of taking effect on July 1st of the year in which they're passed. So now that we've gone through an example of the legislative process in action, we'll give you some tips for communicating with legislators. This slide includes the contact information for the legislature, including the mailing address and the information for the Legislative Information Center, which sort of coordinates communications and getting communications to legislators during the session. It's important to know that all mail, email, and faxes must contain your name and address in order to be delivered. You need to make sure to identify the specific legislators that you are contacting. And finally, be respectful. It's essential that we have the ability to work with legislators on really a broad array of issues. And even though we may be on different sides of one particular issue, we have to have the ability to go to a legislature in the future at some point down the road and have them listen to us with an open mind. And that can only happen if we've treated them with respect and we've built a relationship based on respect. And so our communications always urge city officials to be respectful and deferential to legislators. And a legislator who votes with us one time out of 10 or even one time out of 20 can still be tremendous help to us. And we can only do that if we foster an attitude of respect to them. Testifying at a legislative committee is very similar to a local government hearing. The process is pretty similar. The main difference is that there's less notice for legislative committee hearings. Generally, legislative agendas are posted online only 1 or 2 days before the hearing, and so there's not much advance notice. So for that reason, you want to call the committee secretary or email the committee secretary to find out when the bill will be scheduled for a hearing. We have people traveling hundreds of miles, sometimes flying into Boise here, and so it's critical to nail down when exactly the proposal will be up for a hearing, or if it will even be heard in a committee. Sometimes the committee chairman says, I'm not interested in scheduling the bill for a hearing. It's a good idea to bring written copies of your testimony. This helps you to really focus on your key points when you're writing your written testimony and allows you to summarize it better when you're speaking before the committee. It also makes it easier for the committee secretary when they're doing minutes. In the legislative process, you need to be early and be prepared to wait. Not everything happens at a specific time. The morning committees generally meet at a specific time, but the afternoon committees generally meet upon adjournment of the House or Senate, which means that the committee meeting doesn't start until the House or Senate finishes their business on the floor. So that could be anywhere from 1:30 to 3 o'clock in the afternoon. So be there early and be prepared to wait. Just like at city council hearings, there's a sign-in sheet that's provided for you to put your name on and indicate whether you wish to testify. Part of the process is showing respect and deference by addressing your comments through the committee chair. So when you're asked a question, you respond, Mr. Chairman and Representative Smith, I appreciate your question. It's a little more formal than city council hearings, but legislators generally aren't caught up or wrapped around the axle with formalities. They really want to hear what people have to say, and hearings are generally relatively informal and open to people to come and share their views on legislation. Not everybody who testifies at a committee hearing is a professional lobbyist. There are lots of citizens who are engaged in the process, as they should be.